नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Diversity in terms of languages. The 15th century, 14th century idea of what is a nation or a nationality, which was so centrally founded on language, I don't think would work in a country like India. So linguistic diversity meant that you have countries which are actually a bundle of people speaking different languages. So you will notice that we no longer use the 14th century, 15th century, 16th century word of nation state. We are using the word country because we understand that within one country there can be multiple people speaking different languages. I still do not use the word nationality, that we have different nationality because India is seen as one nation. Okay, there are many political thoughts behind it, and it would do you good to read up a little more on what we mean by a country and what we had earlier meant, political science had earlier meant by a nation state. Now, unity and integrity of a country, which is there by the 42nd Amendment, appears to suggest that there can be no diminution of the boundaries of the state, that what we have is what we are continuing to have. When India ratified the International Covenant on Civil and Political Rights, and when it ratified the International Covenant on Economic, Social and Cultural Rights, it entered two very important reservations with regard to each of these. And as students of law, you know that these are international treaties, and India, by ratifying, becomes a party to these covenants. But at the time of ratifying, it also entered what we call reservations. That is, they are ratifying it subject to these reservations. And the most important reservation was entered into by India to Article 1 of the ICCPR. That is, we recognize civil and political rights, but we do not recognize the right to secession. Okay. Secession. That is the right to secede out and territorially exit from the unity. Now, it's also around the same time that we have the word unity and integrity of India added in the preamble. So I'm going to examine two questions over the next two classes beginning today, which is, when we say that the unity and integrity of India is inviolable and we put it in the preamble, does it allow India to take out territory from India? Can India cede territory? Okay. Secession and cession are two words that I'm going to use. Please be, There we go. Secession and cession. When I use the word secession, we normally mean a group of people breaking away from the country and going away on popular demand of one group of people. When we talk of the word secession, we are talking of a state act of ceding and giving away territory governmental. And so the initiative for the action, if it comes from a group of people, we normally call it secession. And when the government gives away the land or something, then we normally say it's ceding that territory, it's giving away, we're calling it cession. So please be clear about the two words that I'm going to use, and if at any point in the class that there is confusion, just remember to ask me. So, what is it that the question that I'm going to raise in today's class? When the preamble has unity and integrity of India, is there a power for India to cede property or not? The converse question, is there also a power to acquire property, is also there. However, the politically more troublesome question is the giving away of property. Because I think every country has this wish to, a little bit of an expansionist wish to take on new properties, but the giving away of property is somehow seen as a anti-national act, and should you be allowed to cede or not? So those are the two questions which we have in today's class. And I assume that many of you have begun reading Intri Berugari Union, and that's where this question is raised. But in order for us to understand the constitutional and legal background on which the question that I'm asking, does India have a power to cede territory, we look at Article 1 very closely. The second question that I'm raising, and it is again a part of this, is that is there a power to take away proper land from a state and give it away to another state? That is, it is within the corpus of the territory of India, but from state A, you're carving out a piece of land and giving it away to state B, or you're carving out a piece of land and creating a de novo new state called state C. So from Madhya Pradesh, you carve out and you make Chhattisgarh. Is it constitutionally permitted? Or those of you who follow political debates keenly, the question of two villages, Abohar and Fazilka, to the districts of Abohar and Fazilka, do they belong to Haryana or do they belong to Punjab? Which at the height of the Punjab agitation, when the great Sant Longowal Rajiv Gandhi Accord was signed in sometime in 85 or 86, was the central issue in that Punjab discord, whether these two villages should move from here or to there. So there are these kinds of things. We do not use the word cession, we do not use the word ceding when we are talking of interstate land transfers, because cession and secession and ceding is only when you're giving it away from your country to another. Now let's look at Article 1 subclause 2 and Article 1 subclause 3 in detail. Article 1 subclause 2, please have it open. I want that constitution with you. You must follow it, because we are now coming into the actual constitutional text, and no amount of story or narrative can displace the hard black letter of the text. The states and the territories thereof shall be specified in the first schedule. So I showed you the first schedule, which has only two parts right now: states and union territories. Before the great 7th Constitutional Amendment of 1956, the first schedule comprised Part A, Part B, Part C, Part D states. And Part A, Part B, Part C, Part D, I'm not giving you the full answer. You should be able to do some research on your own. But it also parallels and mirrors and reflects the position in India just prior to the adoption of our constitution, where we had different types of territories that became part of India. There was the directly ruled British India. There was the princely states, 562 or 63 of them, which chose to merge with India. And then we had those territories which were not part of British India in the sense that they were not directly under the Governor General, but were administered by a chief commissioner. And these were chief commissioners' provinces. I'm going to leave it to you to do some broad reading to find out which of them corresponded to Part A, Part B, Part C, and then you have the mysterious Part D states. So that all got changed when in India we had the 7th Constitutional Amendment. And 7th Constitutional Amendment is of course one of the very, very important amendments. Let me just go off a little bit on a tangent. Yesterday, many of you may have read Professor Upendra Bakshi's article in yesterday's Indian Express, where he says that the judgment in Keshwananda Bharati is a supplement to the Constitution of India, and that it is the second most important document after the Constitution of India. And it's a beautifully written article. I suggest you just very quickly locate it and read it, and if you can, somebody just share the link on the chat group so that everybody can read it. Now, he's chosen the judgment. I'm talking about the 7th Constitutional Amendment, and this is a very important amendment because it rearranged the borders of very many states in India. Okay, how did they do this? Can they do this? Why did they do this? I'll come to, but first let me tell you what the 7th Constitutional Amendment did. It decided, because when these states had all merged into India, thank you, Yugal, when it merged into India, I told you initially it was Part A, Part B, Part C, Part D, depending on the provenance from which these people came. So you had a whole bunch of states which were, you had something called the United Provinces. It had all the Awadh, it had all the other ones. Then you had a state called Madhya Bharat, which consisted of all the centrally ruled states. Then you had Rajputana, which had all those little Rajasthani. Okay. Now, the decision got taken by a commission that state borders will be drawn linguistically, and therefore the State Reorganization Commission, and it is one of the historically is one of the most important commissions that India has ever had, and based on that, the report came in 55, and then in 56 we had the amendment. Every state border got redrawn linguistically. Linguistic majorities were kept in one state and with minorities. And when we come to the second semester, you will know that linguistic minorities is a very big thing. Almost as big as religious minorities are linguistic minorities, because they had special rights in Article 30. Okay? And therefore, linguistic majority and minority states. How did this happen? It's because the power is contained in our constitutions, in our Articles 1, 2, 3, and 4, allowing a redrawing of state borders. And therefore, in a blip of an eye, people who were Punjab got carved out, Himachal got carved out, Haryana got carved out, and Punjab remained. But the jewel in the crown was Chandigarh, and therefore Chandigarh had to be shared between Punjab and Haryana, and therefore language became very important, and therefore the slogans of that time, the political slogans of that time, are you a Hindi speaker or a Punjabi speaker, became extremely crucial. And you will find that if those of you who are from North India, if you talk to your grandmothers and people of that generation, you will find that people who were earlier would read Urdu newspapers and would speak Punjabi at home. A transition also happened, and people were speaking other kinds of languages in home, and language became a very big thing. And as you know, language is perhaps, I've had occasion to mention it before, that language was the toughest clauses of our constitution, and language continues to be a very, very hot topic. You just look at the new education policy, language has been the chief issue, and you know that now the newest draft and the adopted draft, finally, between the draft to the final document, in language, choice has been given. Choice to the state, choice to the child, choice to the parents. All kinds of parties have now got choice about what language you must study. Now, I'm going to just quickly for a moment look at the American Constitution, so that my point that I'm going to make in class will be a little clearer. Now, Article 4 of the American Constitution, Section 3 of Article 4 says, new states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states without the consent of the legislature concerned as well as the Congress. That is, without the consent. Now look at this word here. Without the consent. That is, you have to hold up and say, yes, hara jhanda dikhana hai. Only then can a state's borders be changed, or can a part of it be given away to a new state. To put it in legal words, the American Constitution guarantees territorial integrity of a state, and only with the consent of the state can the state's borders be changed. In contrast, look at what our constitution says. And yesterday we had noted that this lack of territorial integrity on the part of the state was taken by the judge yesterday. The paper judgment we were reading, Chief Justice Sinha says that perhaps this is one of the most important reasons why we do not call the Indian Constitution as a pure federal constitution and as a quasi-federal one. Now look at, for this, let me look at Article 2. Parliament may by law. Who can do it? Parliament. How can it do it? Not by executive order but by law. Parliament may by law admit into the union, that is, you admit de novo a state into the union, or establish new states on such terms and conditions as it thinks fit. Now look at the two differences. Admit into the union a new state. In 1975, the erstwhile kingdom of Sikkim was admitted into the Indian Union as a state. Sikkim was admitted. It was earlier separate from the Indian Union. It was brought into the Indian Union in 1975. We're going to go into the Sikkim case. There's a very important 5-judge bench decision of the Supreme Court, R.C. Paudiyal versus Union of India. I'm going to look at that. But I'm just mentioning it here as admitting it. Goa. After the Portuguese left Goa, and after Goa was brought in 1960 or 61, I can't remember, Goa is an example of a country that was admitted into the Indian Union. Pondicherry, Chandranagore, it doesn't become separate. Chandranagore admitted and becomes part of West Bengal. So you have other ways in which states can come into it. Now look at the second word. Or establish new states on such terms and conditions as it deems fit. Here you're not bringing in a fresh territory, you are establishing a state. I've already taken the example of Chhattisgarh being carved out as a new state from the erstwhile Madhya Pradesh, leaving the old Madhya Pradesh in its truncated form. Okay? So that would be establishing it as it deems fit. Now, if I were to contrast Article 4, Section 3 of the American Constitution and Article 2, as students of law, you can readily look at this. And what will you find out? You will find out that the power has been given only to Parliament. There is no requirement when I am carving out one state and bifurcating it into two. The consent, I'm using that, just looking at the word consent. Do they have a voice is different from do they have a consent? And I think as students of law, if I was to ask you,
your mic has been put on mute.
have I not been having the mic so far or just now?
I'm just now.
Just for 10 seconds.
Okay. What's the difference between voice and consent? Because this is a distinction which I'm going to use to just contradistinct to Article 4, Section 3 of the American Constitution. Yes, anybody? Which is a deeper right? Right of voice or right of consent?
Right of voice or right of consent, it depends.
Okay.
Right of consent.
Right of consent. Yeah, okay. Now somebody is written here, Shovik. Shovik Mohapatra. Yeah, just tell us why you think consent is a deeper right. Just speak, please. Shovik.
Hello?
Yes, we can listen. Yeah, please speak.
Consent needs express authorization, whereas voice doesn't need so.
That's right. Does everybody agree to it? Because
Yes, ma'am.
voice is only consultation. That is, I have a duty to hear you and I've heard you. but decision mera hai, right? So it's only a right to be heard, a right to speak. But consent says that the decision must also be in consonance to with what I said. And our constitution uses two words. It uses a word consultation. And since all of us are law students, we know that in the appointment of judges, the most difficult word has been that word consultation, which is there in Article 124 of spelling is wrong, but what I meant was consultation. That is you have a right to voice. So I think you can see straight away that voice is only equal to consultation. Consent, and thank you, Akash has pointed out concurrence, that is another way. So definitely the word used in the American Constitution was consent. That example was available to our Constituent Assembly because they knew this. Yet they chose another word, and what we want to find out is why did they choose it? So here, admission, Parliament may by law admit into the Union or establish new states on such terms and conditions as it thinks fit. Okay. Now come to Article 3, which is a little more detailed dealing with states. I'm first going to quickly run through all four and then I come back again to Article 1. Okay? I want to do it in that style. Now look at the marginal note of Article 3. Which is the marginal note here? Formation of new states and alteration of areas, boundaries or names of existing states. Now, is the marginal note a part of the article? This is a question that has repeatedly come up in constitutional interpretation. And the marginal note, you know, is the one that is printed on the side if you have the official, or if you have one of these things that I have, then it's printed on top of the article. Okay. Formation of new states and alteration of areas, boundaries and names of existing states. Sometimes the marginal note contains a phrase which is not to be found within the main article, or it may present it in the form. So very famously in Article 368, earlier before the amendment, it used to merely say the procedure for amendment in Article 368, and this became one of the most central arguments in Golaknath versus State of Punjab, the 11-judge bench, because they said there's only laying down a procedure, it's not giving you the power. The power has to be located elsewhere. So the marginal note is a very important, what we call in law, an aid to construction or an aid to interpretation. So the marginal note also has immense value. Now look at Article 3. It says, again, it begins by Parliament. Parliament alone has the right. Parliament may by law, meaning it's not an executive function, it has to be done legislatively. Why am I flagging this? The reason is that when I start Berubari, and those of you who've begun reading that case know that when India enters into a treaty with another country, it is a pure executive action and it's not a legislative action. India does not require treaties to be ratified by and large by Parliament unless there is an infringement of a right. Otherwise, it's an executive action. I'll explain that more when I come back to Berubari. Parliament may by law A, form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of the state. Now look at the myriad ways in which we can form a state. A, form a state by separation of territory from any state. Which is the example for this?
Telangana, Hyderabad.
Telangana. Yes, absolutely. Telangana from Andhra Pradesh. Chhattisgarh from Madhya Pradesh. Jharkhand from Bihar. Very good.
Haryana from UP.
Uttarakhand from UP. Haryana from the old Punjab. Himachal from the old Punjab. Okay. Or by uniting two or more states.
UP is united by two states. Four states. And Kerala.
No, wait a minute. When you're talking about Harit Pradesh and all which are proposed?
Yes, ma'am, Bundelkhand and all these.
No, but that was United Provinces, right? So CP and Berar, Central Provinces and Berar got merged with Madhya Bharat to become Madhya Pradesh. Okay, that would be example. In Kerala, Talukor and yes, somebody was saying something.
Ma'am, Puducherry.
Donika, speak.
Ma'am, Puducherry.
Puducherry had merged with what?
And so there were four, when it got independent in later on, then there were four different parts of the country. Those were merged together to form Puducherry. And not merged as in merged into one union territory.
Yes, good. Pepsu and Punjab. Yes, somebody else, man.
Recently, the other one, Nadu Haveli with Daman and Diu.
With Daman and Diu. Yes, so we've all got, we are on top of all those examples. Or by uniting two or more states or parts of states. So you not only unite two full states to make one. I took the example of CP and Berar, Madhya Bharat. But you can merge a part with an existing state. So when you read Indru Berubari, the princely state of Chandranagore merges with West Bengal. Okay, after it. Many, like yesterday somebody talked about, which was the state that we were talking about, the one in Gujarat, where the referendum was held. Junagadh, that's right. That's right. Or by uniting any territory to a part of a state. That is, you have a little bit of land extra, you merge it. So, Abohar and Fazilka, which were on the border, the question was whether it should go to Haryana or it should go to Punjab, okay? And there was a Justice Matthew Commission that went into it, that conducted a census, and the decision was taken based on what language was spoken. Are they Hindi speakers or Punjabi speakers, okay? So, big campaigning about which language to return, and then it accordingly merged. Okay, so that's A. So we can see in A, you're not taking any new territory from outside India. You could, but we are also talking about within the corpus of the land available in India. Now come to B. Increase the area of any state. This is not independent of A, because you can increase the area of a state either by having completely new territory added to it, like my yesterday's example of an island that comes up in the Bay of Bengal outside Sundarbans will become part of West Bengal, okay? Or at the cost of another state. So Abohar and Fazilka that went to, I forgot where they went to, whether it went to Haryana or Punjab, you'll have to look, I forgot. But if it went to A, it went to Punjab. Okay, then it would have been at the cost. Diminish the area of any state, alter the boundaries of any state, and alter the name of any state. You will see that they can completely override the parliament by law, can take over. And I think the most recent example would be Kashmir. The new Kashmir Reorganization Bill, which now says that the state of Kashmir, Jammu and Kashmir, is now what? Is a union territory and without the
legislature.
With the legislature, and with Ladakh. Okay, that's an example of this.
Professor, I had a doubt regarding what we've discussed so far.
Yes.
So basically, the idea of territorial integrity that we have discussed of a state. So we are, I mean, a lot of critical commentary for democratic countries, nation states, is that the minority gets stifled in a very basic sort of layman universal understanding. But my problem with the theory of secession, especially vis-a-vis Indian Constitution, and I'm mentioning this because you brought up the abrogation of Article 370. So like Kashmir's right to secession, whereas on one hand we have a document as such, the Constitution, which is supposed to be a defender of civil rights, human rights, a defender of freedom, but it's to me it has a very
it's not very clear to me why you are talking about secession in the context of the presidential proclamation of August 5th, because that was under Article 3, read with Article 370, and I'm talking now about the alteration. Secession is, let's be clear what we are talking about. I said the unity and integrity of India does not permit secession. That is, a group of people cannot get up and say that we are taking away from the territory of India. But I said that taking away property, land from one state and giving it to another is not secession. Okay, it's not secession. So, first, I'm sure you followed what I said, but just to re-clarify in case there's any doubt. When you pick up a state and you say you're not a state, you've become a union territory, that's nothing to do with secession. This is on terms of Article 3. Okay? And the other point that you are talking about, when we create a state, when we alter the boundaries of a state, of course, the language spoken in the state may change. It so happened that when Telangana and Andhra got formed, Telugu language continued to be the official language of both these states. Okay. However, when the linguistic reorganization happened in 1956, the old Madras state got divided into Tamil Nadu, and part of it went away into Andhra Pradesh, that is the Telugu speaking part. So Tirupati as a temple used to be in the old Madras state. Now you know that Madras, Chennai is right up on the north, and the borders got drawn just about 50 kilometers north of Madras, and then Tirupati, which is about 100 kilometers away from Chennai, went away into Andhra. That's because of language. Okay, so the point about secession I don't think is apt here. Your other point about language borders changing the linguistic majority-minority issue, I agree. Okay, so Anjali, just hold your point. Let me finish just first the understanding of the law before we start looking at the pros and cons and the political fallout of this. Okay, that is generally speaking my structure of all my classes. Unless we are very clear on the black letter law, I think commenting on it becomes a little. So just hold your thought for a moment. Let's now come back to the proviso. Provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President. I'm going to just stop here. Provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President. Normally, bills are introduced when the cabinet decides that these bills will be moved, then the appropriate minister who is responsible for that bill will pilot that bill in Parliament. So, for example, there was a news item 4 days ago that Parliament has approved those other three major labour codes, social security, occupational safety and health, to be approved, and in this new current session of Parliament that's going on, they're likely to be introduced. But here what? You need prior approval of the President to bring it in. And you can see that, even if you're not aware of it, just believe me when I tell you that normally the bills after being passed by the two houses go to the President. You don't require prior approval of the President to introduce. But here is one of those rare instances where prior approval of the President, even for Parliament to debate. Why the President? You can see because there are state concerns and you don't want the central government to overly override. Except on the recommendation of the President, and then now I'm continuing, and unless where the proposal contained in the bill affects the area, boundaries or name of any of the states. Area, boundary and name. Name you can understand. Why area and boundary? Why are there two reasons, two words used? Can you change the boundaries without changing the area of the state? Is it possible? Anybody? Yes, Mohan, yeah, explain how you can change the boundary without changing the area.
When we can take a certain part from one state and then give a certain part to other state, and the area might remain same, but the boundaries will change.
Absolutely, and therefore to cover for all contingencies, you have area, so that you don't give with one hand and take away with the other, keeping the area constant. You're also changing the boundaries and the name. Now, what does it say here? Except where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its views thereon within such period as may be specified in the reference, or within such further period as the President may allow, and the period so specified or allowed has expired. I want you all to read this quietly for yourself and then answer this one question. Is the prior approval of the President necessary in every case? Number two, is the views of the state legislature necessary in every case where the state's area, boundaries, or name is being changed? What does that proviso actually tell you? Read it carefully and then I'll call you one by one. Yeah. Take a minute, please, and read it carefully. Couple of people have their mics on, just turn it off, please. It's disturbing. And while you're at it, look at explanation 1 and explanation 2 also. Okay, it's not relevant to my question, but you can just have a look. Okay, so let me take my first question. Is it necessary that before a parliament discusses a law with regard to a state, is presidential prior consent a necessity in every case?
Yes, ma'am.
Yes. Okay. Second question is the expression of the opinion, or what is the word, expression of the views of the state legislature, is it a necessary precondition in every case or not?
No, ma'am. No, ma'am. Parliament is not bound by the dissent of the state.
Shivani, you have the floor. Please speak.
Ma'am, Parliament is not bound by the dissent of the state.
No, I'm not going into what value they'll put to the views. I'm asking you a procedural question. Answer my question. Is it necessary before Parliament discusses a bill pertaining to a state, is it necessary that the bill should have been discussed further, the proposal should have been discussed by the state legislature or not? The second point is what value we know. Yeah.
Second question?
Yeah, ma'am. No, it's not necessary, ma'am, because if the period gets expired, which is granted by the president, so the president might not extend the period. That discretion rests with the president.
That's the second point. But it does every bill that comes before Parliament pertaining to a state border or a state name or a state area require the view of the state to be ascertained?
Yes, ma'am. Ma'am, even if the state...
What is the... Except on the recommendation of the president and unless where the proposal contained in the bill affects the area, boundaries, and names of the state, the bill has been referred. So is there a contingency here where you can discuss the bill without asking for the views of the state? What does that English mean?
If the bill affects the area's boundary or names.
Then only you will take the view?
Yes, ma'am.
So then what? Tell me a contingency where you may be discussing something about a state without dealing with the state boundaries and area. but still which requires the presidential prior consent. What kind of thing could that be?
Diminishing the area of.
But that would be area, no? Affect the area is both enlarging and diminishing.
I'm changing the name of the state.
But that is already there in the unless. I'm asking you, it says unless where the proposal contains, let's put it positive. If every which is dealing with Article 3, if there is a bill pertaining to Article 3, Parliament cannot discuss it till you get prior permission from the President first. Number 2, if the bill is pertaining to its area, boundary, or the name, you need another necessary condition. And what is that second necessary condition? That you would have sent the bill to the legislature and tried to ascertain their views. This second condition kicks in only if the bill is dealing with the area, the boundary, or the name. Which means that if it is a bill which is not dealing with area, boundary, or name, you don't need to go to the state legislature. You just need prior permission of the president. So my question follow on to that is, what could be a subject matter of a bill under Article 3 which requires prior permission but which does not deal with boundary areas and name? What could it be?
Formation of new states.
Formation of new states. Formation of a new state by de novo land that comes in. You don't need to get the opinion of that legislature because there would probably be no legislature. But if that new state, Rahul, is going to be created from an old state, then that second part of Article 3 will come into play. Article 3 proviso. So, all bills pertaining to Article 3 require President's prior consent. Second, if that bill is pertaining to area, boundary, or name, then please refer it to the particular changing the state. So then I ask, what is that residue where you don't need to go to the state for ascertaining its views, but for which presidential consent, and as you correctly pointed out, it is where you have fresh territory that's being brought into India and you are going to create a new state, not add to another existing state, because then it's altering the area of that state. You have to go back and say, are you okay that we merge it with you? Not then. You've got a new area and you're making a new state. The best example of it would be Sikkim in 1975. It was not added to a state. You were not changing the boundary. It was not a state until then it comes in. Okay.
Now, if you recall, the area is new and they don't have any state legislation, I guess.
Yeah. But if you are taking up a new area and merging it with an existing state like Chandranagar, then that part of the proviso would still apply. Okay. Then there is the other point that one of you said, that if it gets delayed and that thing has expired, even though you should have ascertained their views, for these procedural reasons, you are still good because you tried, but then the state legislature never gave its views. It could happen. How could it happen? If it's a deeply contested issue, maybe the House does not. To express its opinion, it must have to express its opinion in the form of a resolution. And the voting may be so contested, it may be evenly poised, there may be complete breakdown of law and order outside and blah, 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 and so it may never ever happen. Okay. Now, therefore, Article 3 says you only have to ascertain their views. So now you will understand why I asked what is the difference between voice and consent. And you will see that unlike Article 4, Section 3 of the American Constitution, where the word consent has been given, it was deliberately omitted while Article 3 was being drafted in our Constituent Assembly. And the only thing that we have is what? Okay, now you can, if you have a footnote in your Constitution, you can see how it stood by, this is under the 5th Amendment, okay? Look at how it is in the provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President, and unless where the proposal contained in the bill affects the boundaries of the state, etc., Part A, Part B, in the first schedule, or the name of any of the views of the legislature with respect have been ascertained. Okay, that was Part A, Part B. Now it's there. So we only have a little more diluted provision of voice and not consent. That's true, Rajneesh. I agree with you. And that is why one of the principal reasons why we say we're not really a federation. Because if we were a federation, then the consent of the states, they have their right to say various things, and it has been diluted in very many forms. Now look at the explanations. And I'm going to use this because there's a very important argument that comes up in Indri Berugari. I'll go back to Article 1, but I wanted to finish Article 4, and I'll come back to the case law and the Article 3, later again. Look at explanation 1. In this article, in Clause A to Clause E, state includes a union territory. But in the proviso, state does not include a union territory. What is the political significance of explanation 1? Anybody?
Ma'am, in the case of affecting the area boundary or name of an union territory, the state reviews will not be required by the union while doing this.
Is it possible to have a union territory with a legislative assembly?
Yes, ma'am.
Yeah, give me an example.
Delhi, Puducherry. I would have liked to of Delhi and Pondicherry.
Okay. And what about Ladakh?
No, ma'am, it won't apply.
Ladakh doesn't have now? After the August 5th reorganization?
No, Ladakh too has.
Ladakh also has. Now, because it's a union territory, because it's directly administered, the executive power is represented by the central government, which is a part and parcel because of our very peculiar non-separation of powers and fusion of powers, is also represented in the Parliament of India, and therefore when they are going to debate that law under Article 3, they definitely are going to talk about it. And therefore, while the word state in Articles A to C, you can increase the area of a state, you can diminish the area of even a union territory. In this method, the ascertainment of views does not happen. Now look at explanation 2. The power conferred on Parliament by Clause A includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. It's just a clarification. Now here is Article 3. We're going to bring all of this to bear when I come back to Article 1. And now look at Article 4. And it's a very, very important article for us. What does it say? Any law referred to in Article 2 or Article 3. Article 3 is completely dealing with states and state borders. Article 2 is dealing with establishment of new states, and it is dealing with admission of new territory into India. That's the distinction between 2 and 3. Okay. Now, Article 4 says, any law referred to in Article 2 or Article 3 shall contain such provisions for the amendment of the first schedule and fourth schedule. First schedule is delineating the territory. What does fourth schedule delineate?
Allocation of seats to Rajya Sabha.
Very good, yes. So, it will obviously have corresponding amendments. When you increase the area of a state, then the population will increase. Therefore, relatively, you may have increased the population based on delimitation. That maybe you get one more seat in the Rajya Sabha, and therefore there is a corresponding amendment to first and fourth schedule. But now look at what the fourth schedule says. What does it say? It says, shall contain such provisions for the amendment of the first and the fourth schedule as may be necessary to give effect to the provisions of the law, and may also contain such supplemental, incidental or consequential provisions, including provisions as to the representation in Parliament and in the legislatures of the state or states affected by such law as the parliament may deem necessary. Yes, so you have to amend 1 and 4 and consequentially. But most important now come to 4 clause 2. No such law. Which law? The law made under Article 2, admitting new state or establishing a new state, or under 3, altering the area, boundary, name, etc. of any state, shall be deemed to be an amendment of this constitution for the purposes of Article 368. So at one stroke, what does 4 subclause 2 do? It says you are amending the constitution because you're going to amend 1st and 4th schedule, but it's not bound by the procedure in Article 368, which means at the very minimum, you don't need the special majority, 2/3 present and voting. You could get it done by a simple majority. It will not be listed as a constitutional amendment. So if you look at the end of the constitution or any book which lists the first to whatever we have now, 120th or whatever is our amendment, it will not be listed there. So if you look, the creation of Chhattisgarh, the creation will be called as Reorganization Act. It will only be called as an act. It will not be treated as a constitutional amendment act. वो गिनती में भी नहीं आएगा. It would be like that. However, Andhra and Telangana don't.
Excuse me, ma'am. It's already time. It's 1:28.
Oh, Priyasha. Okay, let me finish this point. Okay, that is when you look at Andhra and Telangana, because we were amending Article 371 capital D, it was moved as a constitutional amendment. But if it's only done by a law, you know that Article 370 and 371 has actual constitutional provisions dealing with Kashmir, Jammu and Kashmir, Telangana, Nagaland, Meghalaya. So when you are changing anything in those states, it requires an amendment. But when you are operating under Article 3 and 2, then it is not a constitutional amendment. Okay. Now for tomorrow's class, please everybody will start reading Indru Berupari and come, because I wanted this background of 1, 2, 3, 4 so that we go back to 1 with this knowledge. Akash, if you can, we bypass the second part of the proviso if the state is under residence rule. That's a good point. And the answer is yes, you can. Babulal Parate versus State of Maharashtra. Okay, so let me quickly take attendance because you all have another class. Diversity in terms of languages. The 15th century, 14th century idea of what is a nation or a nationality, which was so centrally founded on language, I don't think would work in a country like India. So linguistic diversity meant that you have countries which are actually a bundle of people speaking different languages. So you will notice that we no longer use the 14th century, 15th century, 16th century word of nation state. We are using the word country because we understand that within one country there can be multiple people speaking different languages. I still do not use the word nationality, that we have different nationality because India is seen as one nation. Okay, there are many political thoughts behind it, and it would do you good to read up a little more on what we mean by a country and what we had earlier meant, political science had earlier meant by a nation state. Now, unity and integrity of a country, which is there by the 42nd Amendment, appears to suggest that there can be no diminution of the boundaries of the state, that what we have is what we are continuing to have. When India ratified the International Covenant on Civil and Political Rights, and when it ratified the International Covenant on Economic, Social and
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा। कमेंट बॉक्स में अपना फीडबैक देना ना भूलें। थैंक्स फॉर वॉचिंग।